theory behind what is called new urbanism. Okay, so it's new urbanist development. The classic new urbanist development is Seaside, Florida. Anybody see the movie The Truman Show?
Mm-hmm.
It's a while ago, right? Okay, right? So it looks kind of Disneylandish residential, right? And it's all a movie set. Okay, that is a new urbanist development of Seaside, Florida. Okay, that's where it was filmed. Okay, so part of the point is that it is a little bit like Disney came in and constructed a little town for you to live in. Okay, so it is because one of the things is all of those architectural styles, they did not all exist at the same time in the same place in cities. That's just wasn't how it worked. Okay, so that's one thing. But the other thing about Norton Commons is that new urbanism was meant to prevent or reduce sprawl by having this more compact development where everybody could walk to things. But the theory was that it was going to be a great kind of development for what we call infill development. That you could build it, in the core of the city, and people, and it would create this sort of pleasant village-like experience in the core of the city and so forth. Well, Norton Commons was a field out in the, out beyond the Gene Snyder Freeway, right? I mean, it's basically cute, a little bit more compact sprawl, right? I mean, it's that particular development. And there was a study, I think it was the Journal of the American Planning Association, but it was done a number of years ago, so maybe a little bit out of date. But what they found was that more than 2/3 of all new urbanist development was greenfield development, was out in the, on the edges of town in, sort of undeveloped land as opposed to being infill development. Okay, so that's been one of the, and I don't mean to pick on Norton Commons, I'm just trying to say, that sometimes when we talk about, hey, we want to do mixed use, what we're doing is we're sort of artificially creating some places where that happens, okay, as opposed to being more organic in the way that Jane Jacobs talked about. So, by the way, I also want to ask all those people who live out in Norton Commons, how many of them get in their car and drive to Home Depot or drive down to Bardstown Road for dinner, okay? Yes, I mean, some of the time they walk down the street to dinner, but, I mean, really, it's not like that becomes a totally self-contained, self-sufficient community, okay? Even though theoretically it could, in reality it doesn't, okay? So that's one thing. The other thing I want to kind of address is the extent to which you can use one type of property for another type of use. So this is like the home business thing. Okay, so that's might be one of the things that Pierce is asking about. So if you live in a single-family residential property, I do. Okay, so let me sort of offer a variety of scenarios. I live in a single-family home, zone single-family residential out in eastern Jefferson County, and I grade your papers. I sit at my computer in my family room or on my screen porch and I upload materials for land use class at home, okay? I'm working, right? At home. I'm doing work, right? Okay? Does that violate the zoning code? Am I using residential property for non-residential purposes? Okay, people say no, why not?
Because your primary use of that space is still your residence.
Okay, so my primary space is still residence. So let me ask you a different question. So let's assume for a moment that under the university regulations, I'm allowed to do consultation work 1 day a week, as long as it doesn't interfere with my classes. So I decide to set up my own law practice and bring in I'm gonna do it just 1 day a week, right? So, maybe, I don't know, Thursdays, let's say. Thursdays is my law practice day, and I bring in 40 or 50 clients a day to my house. Does that violate the zoning code? Okay, my primary use of that property is still residential. Right? So with the justification you offered previously does not hold. Right? But your instinct is to say there's a problem with me having 40 or 50 clients coming to my home 1 day a week. Yes.
Would you be required to have a business license if you did that?
I don't know, but we're not talking about the business license. We're talking about business license is actually the business license is mostly about whether I pay some money to the government to allow me to operate business. They don't care. They don't care about the zoning or anything. They just care about do they get their money. Okay, so that's not. But the question is the zoning code. Okay?
So your first example, I think, would qualify as a home occupation because it's just you. You don't have any employees. You're not having any customers coming in. But the second example, you got so many people coming and you need extra parking, and that would be like an expanded home occupation. Right?
Okay, and so what's the problem? Okay, you're almost on it, but just keep going.
Does it just depend on how your use impacts the other people's use around you?
Yes, the neighbors, right? The surrounding land uses, right? Okay, so you see where we could keep pushing to what's the problem? It's the number of people I have coming. Where are they going to park? Right, the traffic, right, and so on and so forth. The shift in the kind of the character of the neighborhood, and maybe it's only 1 day a week, but 40 to 50 people per day is a lot. Okay, now, a couple of things about this. Just again, we're constantly kind of questioning our assumptions and sort of thinking a little bit more deeply and nuanced about these things. Okay, so there are localities, local governments that have tried to enforce residential zoning against people who are bringing their work home with them, and it's just them and their computer in their, den or dining room or whatever. Okay, so there's a famous example from Chicago where the person was working on, some sort of account. They were an accountant, and they bring their books home and work on it at home, and the city was saying that they were violating the single-family residential limitation. Now, having said that, it's my understanding that the city lost. Actually, what happened is that it got published in the newspaper, and the city was so ridiculed that they backed off, right? I mean, the publicity ended up being bad for the city. But the point is, think about what's going on here. Think about how this works and what's happening. Why would this happen? And let me ask you this, okay? You sort of think, well, how could a city like Chicago or how could Louisville in any reasonable way enforce this, right? Right? Does everybody see that? But what if you have some little small community that is pretty much residential only, but is a standalone city with its own zoning, right? And everybody's maybe it's like mostly retirees, okay? Okay, now I don't want to make too many broad assumptions, but what do we know about property, neighbors, and retirees? Everybody pays attention to what their neighbors are doing, right? Right? I mean, yes, they're okay, right? Yes, I mean, so in California, one of the really common experiences where you would have these subdivisions that were highly regulated mostly by covenants and deed restrictions, what we call CC&Rs, covenants, conditions, and restrictions. So these are deed restrictions. So it's not zoning. These are private, and you have a homeowners association, so forth. But they are enforceable. They're property restrictions, and they're enforceable. And you would have people who are constantly peering out their mini blinds to see if their neighbors had left the garage door up too long or left the trash bin out of the street too long, right? Hadn't clipped back the dead rose on the rose bush, right? Okay, people who have too much time on their hands, right? A little too controlling of what their neighbors are doing, right? So you could imagine a city where, or a municipality where the zoning is exercised that rigorously. And, you know, hey, people are checking. Are somebody actually doing their work at home? Or why aren't they going into the other town and doing their work at the office? Okay? So what I'm trying to say here is I actually think if that were challenged legally, the city would lose. Okay? So I think the city would lose, and the reason the city would lose is exactly what Olivia said, which is that it has to do with the impact on the neighbors. Okay? So this is what we call the land use nexus. Land use nexus. Okay? I'm going to mention this frequently, but the basis for regulation has to have to do with the impact of the land use on surrounding properties, on the public infrastructure, streets and traffic, that kind of thing. Okay, so I mentioned the example from Laguna Beach where they were trying to regulate what brands and how fancy the brands were in the stores. Okay, the Laguna Beach tried to do it, but it ultimately failed to work because there's no land use nexus. Okay, there's no adverse impact on the neighborhood whether you are, buying a, $1,000 Gucci belt or $100 Gucci knockoff belt, right? I mean, does everybody see? Right? Do you see the point that there's no land use nexus? So you cannot use the zoning code that way. But once you start getting into clients, customers, that kind of thing, now you start having impact. You have impact on the streets, you have impact on the parking, you have impact on the character of the neighborhood, and so on and so forth. It's different. Signage. Signage now becomes a problem. Now, having said that, right out, it's not my neighborhood, but it's one or two away. There, somebody has a dentist office in their home, and they have a sign out. You know how they got that? It's probably some sort of variance or exception, but there we are. But let me push a little bit more on your thinking. Okay, so my neighbor directly across the street from me works from his home, and he does not have any clients or customers who come over. He's got grown adult children and grandkids and so forth, and those cars come and go. So, but no business impacts from things like clients and customers. However, Amazon, UPS, U.S. Postal Service, FedEx show up multiple times a day, every day, with deliveries and pickups. Okay? Now, is this something that can be regulated? Do you see now we're kind of on that slippery slope, right? So, it's not clients and customers. It's not that big an impact. How's that different than somebody who is living there residentially, who just orders a lot of stuff from Amazon? Okay, that would be the person across the street from him, me. Which I was totally non-Amazon, anti-Amazon until this year when I went to Portugal and Belgium in November and suddenly needed to buy a lot of Christmas gifts really fast once I got back and get them delivered really fast. And so then I embrace the fact that it's like I'm like a little kid. It's like the new toy, and I'm embracing it. So while my neighbor has all the UPS deliveries, I have all the Amazon deliveries going on at my house. So no, I'm teasing a little bit, but anyway, but you get the point, right? My point here is, at what point is that really all that different from how the kinds of impacts that residences have or not? right? I mean, you see the issue, so it becomes complicated. All right, so let's keep going here. I will upload this PowerPoint later, but this is just some screenshots of parts of the Land Development Code, and this is permitted uses, and you'll see down here. So this is the C1 commercial district, and it allows indoor auction sales, automobile rental agencies, automobile repair garages, automobile sales agencies, billiard parlors, game rooms, and similar entertainment uses, bingo halls and parlors, boat sales and related storage, bookbinding, and blah, 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 and on it goes, right? And so, by the way, obviously, this has been updated sometime or other, because it allows laser tag. Laser tag. So, and there we go. But, so you go through and you see this is on for the list of uses that are permitted. Conditional uses, okay? And then it addresses uses that are conditionally allowed, uses with special standards, and so forth. This is an example of some of the other provisions. Maximum floor area ratio is 5, maximum density, number of dwelling units per acre for different kinds of units, and so forth. Mixed use, office and residential. There's a provision for mixed office and residential use, and so forth. Okay, so you get the idea, and so you go to the code. So legal issues. First legal issue. Does the local government have the authority to zone as it does? Okay. So, for example, does the local government have the authority to zone the use of residential properties for business activity that involves only the homeowner without anybody else visiting them, okay? And so forth. And if the local government does not have the authority, we call that zoning action ultra virus. It's just beyond the power of the government. Ultra being beyond, virus, right? Really like virile and vitality, you know, right? So it means power, beyond the power of the government. Is the zoning action rational? So that's the next issue. If not, the government's action might be an unconstitutional violation of substantive due process. Okay. It might be an unconstitutional discrimination in violation of the Equal Protection Clause, or it might be just plain ultra virus. Okay, so the government does not have the authority to regulate in a way that is irrational, arbitrary, and capricious, so that would be ultra virus. Moreover, if it regulates in an arbitrary, capricious way, it is depriving the property owner of its property without due process of law, substantive due process, and it may be discriminating against a particular class of property owners or a particular class of land users, illegitimately. Moreover, you got to pay attention not only to the U.S. Constitution, but also state constitutions. We're going to see examples from time to time where state constitutions provide more substantive due process and or equal protection than the U.S. Constitution does. So state constitutions have their own provisions, state governments have their own sovereignty, and so state constitutions cannot authorize people, violations of federal constitutional rights, but they can grant more rights than the federal Constitution does. Okay? Next, is the zoning action consistent with the comprehensive plan? If not, it violates the consistency requirement. We talked about that last week. does the zoning action comply with applicable state statutes and local ordinances, codes, and charters? If not, it's illegal. Sometimes the court will use the term ultra virus here. Sometimes they just say it's illegal. Sometimes they just say, fails to comply with the applicable state statute, applicable ordinance, or whatever. Next question, does the zoning action meet the nexus requirement? Okay, must bear a nexus to the land use impacts of the proposed use or development. That's what we just talked about. Okay, so that can be another basis. So, actually, let's stick with this for a bit and then we'll take a break, okay? So we're gonna, so the classic case, the landmark case is Village of Euclid versus Ambler Realty, decided by the U.S. Supreme Court in 1926, okay, just 10 years after the advent of zoning. So 1916, New York City adopts the first zoning ordinance. It catches on like wildfire across the U.S., all kinds of localities, including Little Village of Euclid, which is a suburb of Cleveland, okay? They have a zoning ordinance, and this is a phenomenon that is happening during a time frame in which there is tremendous urbanization, so big increases in urban populations, people moving to urban areas, okay? Increasing size and activity within urban areas. So the U.S. is still more rural than urban at this point, but it's fast becoming more urban than rural. Okay, so that's what's going on at this time frame. Some of that increase in urban population is coming from people moving out of rural areas, off the farms, because life expect. So families are big because, right, ever farm, okay, having more kids, and especially at that time, was essential to operating the farm. That's just how it works. People had lots of kids, and they had then lots of people out, lots of everybody can work the farm and so on and so forth, take care of that kind of stuff. But eventually, what happens is as people live longer and so on and so forth, children survive to adulthood in greater percentages and so forth. Now all of a sudden you have kids who are coming along and they're not going to inherit the farm from grandma and granddad or dad and mom or whatever, right? They're not going to, because the older sibling is going to do that, right? I mean, so now they're sort of figuring out, okay, where am I going to farm? What can I do, and so forth. And so some of them are ending up going to cities because there are jobs. The other thing that had been going on for a while, but vastly increasing in the early 20th century is industrialization, right? Industrialization has been going on for a while, but we see a massive increase, and especially in this time frame, we have World War I that becomes a necessity. It becomes a national necessity to really take off, okay? What else are we manufacturing? Okay, we're starting to get some consumer appliances and so forth. Most of that happens really more World War II and later, but we're starting to get some of that. But we're also getting automobiles, right? So now all of a sudden the automobile's there, and we get in manufacturing of automobiles and so on and so forth. So you have people moving from rural areas. You have, in the shift from slavery to Reconstruction to sort of the Jim Crow and the sharecropping and all of that kind of stuff, you have what is known in American history as the Great Migration of African Americans, mostly from the South, trying to move out of that sort of rural, sort of, in essence, still servitude of some sort, to manufacturing jobs, to cities, to where opportunities are. Much of this is from rural South to urban North, but there's also movement to southern cities as well. There's West and so on and so forth. There's a variety of different kinds of things. But we see that going on. We also see quite a bit of immigration of an international nature. And shifts in who the dominant immigrant groups are. So no longer do we have nearly as many Germans and Scandinavians moving to do, to live in, to farm and do more agricultural work, but we have, Irish, Italians, others coming to work in cities and to work in industrial areas and so on and so forth. And so significant changes in society and significant changes in urban areas. I mentioned the car, okay? So the car is relatively new, and certainly its popularity is growing quickly, and its usage is growing quickly. And so now, what were once long-distance trains, right? People got around, for still, there's horses and carriages and so forth, but there are buggies and carts and stuff. But we went from getting across significant distances by trains to trains now being urban commuter systems. Okay, so all those places out. So for example, the Anchorage. Okay, right? People know the little community of Anchorage here, or go on further out to English Station Road. You know English Station Road, right? Okay, or Beckley Station. Okay, Beckley Station is where you take the turn down to the parklands of Floyd's Fork, to Beckley Creek Park, okay? All that stuff. Station, all that is because there were rail stations all along there where people would live out there and take the train in to downtown Louisville to work, okay? So that had been a development that had been going on, but now people can drive their cars, right? They can live out and they can drive. And so what does that mean? It means certainly growth of suburbs and sort of people wanting to get out of the cities. And what's happening in the cities? We have not only a lot of industrial activity, which is creating pollution and exposure to pollution and stinky conditions and so on and so forth, but also over-concentration of low-income workers in what we call tenement housing. Okay, a lot of high-density buildings, high-density apartment-style kind of housing where people all crowded in, no windows, no fire escapes. There were a lot of serious problems there with it. Actually, was a big part of how the entire profession of social work developed in the United States. Was the tenement housing in our big cities in the early 20th century. But there are people who have opportunities and resources to get away from that, and what are they doing? They're moving out to the suburbs, right? And they have cars now, and they have these commuter rail lines, and so the question is, how are we going to regulate all that? And how are we going to manage all that? And so we have zoning take off. In Euclid's case, we have the land use heightened area districts in the zoning ordinance. These are what we call non-cumulative. Okay, cumulative zoning would be if you could put residential in a commercial zone. If you could put residential uses and commercial uses in an industrial zone. Okay, lower intensity uses being allowed in higher intensity districts. Non-cumulative segregates them all together. You can't have residential and industrial. You can't have an industrial and residential. They're all totally separate. Okay, and so Euclid was non-cumulative, and so forth. And so they aimed to enforce the zoning ordinance against the property owner here, because the property owner wanted to develop their land for industrial purpose, or at least claimed they did, said that they could have developed their land for industrial purpose, but it has been zoned residential, and that has caused their property value to decline by 75%. Property value declined by 75%. The Supreme Court makes a point of that. We call it a diminution in fair market value of the property. This case arises at a period of time in U.S. constitutional history called the Lochner era. It's named, it comes from a famous case, Lochner versus New York, where the Supreme Court was in that case, and in other cases, the Supreme Court was striking down various kind of economic and social regulations, things like workplace regulations and so work condition regulations and consumer protection laws, so statutes and regulations that were, according to the court, interfering with certain freedoms, private property rights and freedom of contract. So basically kind of economic liberties and saying that businesses and property owners should have the freedom to use their property, to conduct their business affairs, to enter into contracts free from unreasonable regulations, and the court was basically striking down a lot of these as being unduly burdensome, as unreasonable in the court's eyes. So, many people thought that it would be likely that the Supreme Court, having taken this case, would strike down zoning as a per se unconstitutional exercise of the police power. That it would be, zoning would be held by the Supreme Court to be an unreasonable interference with private property rights. Okay? And so that was what the expected outcome was. But the Supreme Court, as you know, did the opposite. They upheld zoning as a constitutional exercise of the police power. And one of the things that happened is the case was argued, and then it probably really was not argued very well by either side. And the Supreme Court was really not happy with the arguments, but an amicus brief had been filed by the organization that is now the American Planning Association. It had an earlier name, but it was basically what is now the American Planning Association, which is the professional organization of planners. And you know, it was also a number of cities across the United States who joined in saying, hey, zoning ought to be upheld as constitutional. And the lawyer was named Alfred Bettman, and he had background in both planning and law, and he was a lawyer, and so he was invited by the Supreme Court to argue the Village of Euclid's case, even though he wasn't the Village of Euclid's lawyer, because I think they felt like his arguments in his amicus brief were more relevant to their considerations. And so he did, and then after this rehearing, the Supreme Court came out with its opinion, which is that zoning is a constitutional exercise of the police power. And they said several things. First of all, under nuisance law, private property owners are not entitled to use their private property in any way they want. They cannot cause substantial and unreasonable harm to their neighbors. Okay? They can't substantially and unreasonably interfere with their neighbors' rights. And so zoning is, in essence, just a codification of nuisance law. And they said different uses might be appropriate in some contexts, but not others. So this might be, and they say this is, example of the difference between the pig in the parlor versus the pig in the barnyard. You need regulation to keep the pig out of the parlor because that's not where it belongs. But on the other hand, you designate the barnyard is the place for the pig. So context specific. The zoning protects people's private property values, their investment in private property, because you buy a house and then you can, zoning helps assure that you're not going to now get a factory next door, right? They said that zoning serves the police power, serves the government's protection of the public health, safety, morals, and welfare. And they give some special attention to things like zoning as a way to prevent kids from getting run over in the street when they're playing in their neighborhood, that kind of example, right? And so one of the things that tells us, one of the things we see as a pattern over and over again, is that the government regulation is most likely to be upheld when it protects the public health and safety. So we have public health, safety, morals, and welfare, but those are not created equal. In the court's eyes, okay, the courts are not going to very often step in and tell the government that it does not have the authority to protect people from being harmed or killed, right? I mean, the bottom line is, you know, we kind of, if the government's acting to protect human life, human health and safety, then their action gets more deference from the courts. Morals and welfare, not so much so. There's a lot of different opinion about what affects morals and welfare, and so the courts might be less deferential to those kinds of protections. Not to say that they're going to strike down the ordinance, but they just may be less deferential. Another thing is Euclid reflects the prejudices, socioeconomic, racial, and ethnic prejudices of the time, where the majority opinion goes on and on about calling housing apartments, apartment houses as parasites in local development. Okay. There were no apartment houses at issue in the case. Okay, this was totally unnecessary to address. It was not an issue in the case. It wasn't relevant. This is what we call dicta in judicial opinions. But nonetheless, they seem really worked up about it. Like, oh my gosh, these apartments are going to ruin these nice residential subdivisions. Well, what do they mean? They mean these nice, high income, high to moderate high, white, Anglo-American, ordered, structured, controlled residential subdivisions by allowing in people of different races, ethnicities, lower income people. So that's what they're getting at. I mean, parasite's a pretty strong term. So we see segregation of people being important. And just, I mean, don't forget, okay, so it's been only 9 years earlier, the Supreme Court struck down Louisville's race-based zoning, but as an interference in private property rights, and it's also still this time period in which racial segregation is legally allowed under the Supreme Court precedent of Plessy versus Ferguson. So I mean, we're still ages away, we're decades away from Brown versus Board of Education and other kinds of cases, and even with that, we'll explore those kind of cases a little bit later in the course. A couple other things. Supreme Court upholds zoning as a constitutional exercise of the police power because it's a tool for planning, for rational, orderly, and coordinated development. Serves the public interest, not just the tool of special interest. The court is especially impressed that the zoning has been supported by lots of studies, by evidence presented by experts about why it's needed, all these changing conditions. It strikes a balance between government power and private property rights. And the other big one, of course, is that in Euclid, this was what we call a facial challenge to zoning. In Euclid, the property owner was arguing that all zoning of any sort by any city, anywhere, is an unconstitutional exercise of police powers, an unconstitutional interference with private property rights. So what did the court, with the law that they applied? The court also used Euclid to communicate the basic legal standard, which appears in lots and lots of due process and equal protection cases. And the basic idea is that the courts will apply what's called the rational basis test, and they will do so using the fairly debatable standard. Okay, so when reviewing government actions, the government action will be upheld if it is rationally related to a legitimate government interest. In this case, because we're talking about zoning, it's the police power, the protection of public health, safety, morals, and welfare. The opposite of rationally related is arbitrary and capricious or unreasonable. So if you see the court talking about arbitrary and capricious or unreasonable, it's just the flip side. It's just the other side of it. So it's either rational or it's arbitrary and capricious. This is a different kind of nexus test. We call this a nexus test, but it's different than the land use nexus. It is a nexus about what's the relationship between the government action and the legitimate government interest that is supposed to be served. Is it a rational relationship? Is it a rational nexus? And so when the government makes its decisions, okay, it should, when it's enacting and applying zoning, it should pay some attention to whether the action is rationally related to a legitimate government interest. But the court goes further. In applying the rational basis test, it applies a standard of review called the fairly debatable standard. Okay, so we have the test, and it's applied by the court using the fairly debatable standard. And what the fairly debatable standard says is if it's fairly debatable, so is there a fair argument that the government action is rationally related to the legitimate government purpose, then the courts will defer to the government action. They will uphold the government action so long as there's a fair argument. So if, for example, you get 100 experts together and 60 of them say the government action is irrational, it does not serve a legitimate government purpose, and 40 of them say it's rational, it serves a legitimate government purpose for the following reasons, okay? The court will defer to the government action and uphold it, okay? It will defer to the government and uphold the action even if more experts would say it's irrational than experts say it's rational. Why? Because it's fairly debatable, right? You can have a reasonable or fair argument about whether it is or not. This is not an election. There's no vote. It's not 60% wins. None of that. It's so long as you could reasonably, fairly argue that the government is rationally related to serving the legitimate government purpose, the court must defer. Why? Because it's the elected officials who have been elected, who know their local community, the local context, the needs, who've looked at the evidence and the studies and the plans and so forth of the community. They're the ones who are established in our system for making the decision. And the courts are not going to substitute their opinion about what should happen, even if the courts have a different opinion. So that's the theory behind it, okay? That's the theory behind it. That it's not up to the judges to decide what they would have done if they were the city council member or the planning commission member or whatever, okay? So as long as reasonable minds can disagree, then the court defers. Now, having said that, do not get carried away. In all of these cases, there are arguments being made by reasonable people that the government action is legitimate and the government action is illegitimate. Okay? So just because somebody makes an argument does not mean that the court will automatically accept it. Okay? So, but basically what they're asking is can reasonable minds disagree? If so, we'll defer to the government agency, government action. So another way to say this is courts presume the validity or constitutionality of local zoning. Let me give you, we're going to do one quick, do the Nectow case, and then we're going to take a break. Okay. 2 years later, the Supreme Court almost predictably takes a case and says, well, even though zoning is constitutional on its face, certain zoning decisions may be unconstitutional, may be arbitrary and capricious, may not be rationally related to a legitimate government purpose by looking at what we call an as-applied challenge. As-applied means we're looking at whether this zoning in this case applied to this particular property or this particular development, whether it's rationally related to legitimate government purpose or not. Okay? So much narrower. In Nectow, the city of Cambridge had zoned a property residential, even though all of the property surrounding it was either industrial or a railroad. And so, and the city had arguments. I mean, it wasn't like the city just said, "Oh, yeah, you're right. This was a crazy decision. We just adopted it because we were crazy that day." No, that's not what they say, right? They have arguments, but the court says, "Okay, come on. There's no rational basis here. Even though we would normally defer, there's not a fair argument that this is rationally related to legitimate government purpose because there's no purpose to be served by having this little island of residential property surrounded by industrial." Okay? That doesn't serve the comprehensive plan of the city. And so they struck it down as unconstitutional. So that gives you some feel for what's going on. Now, one quick thing is sometimes you will see substantial relationship. And in Nectow, they use the word substantial rather than rational. In Euclid, the court sometimes says substantial and sometimes says rational. Okay, does that make any difference? Okay. As we look at all of the zoning cases over the years, the answer is no, not really. What the court is saying when it says substantial rather than rational is this has to be, when we say there's a rational relationship, there has to be a real relationship in fact, not just speculative or tangential. One of the things that happens is lawyers for the city can sometimes come up with very clever arguments for why the ordinance is constitutional, why it's rationally related to some legitimate government purpose, even though that's not at all what the city was doing. Okay? And so what the court is saying when they say substantial is, okay, we're going to defer to the city, but the city has to have some real basis for what they're doing in the legitimate government purpose, not just some speculative or tangential purpose. So, if the residential use is in an area that's all surrounded industrial, that's arbitrary and capricious. The line, of course, part of what the thing is, Cambridge was arguing they had to draw the line somewhere, and the court says, well, but the line drawing has to be reasonable for the property owner. They do have private property rights. All right, so let's take a break, and we will come back here at, maybe just take a 6 or 7 minute break, and we'll come back here at 20 or so. courts would strike down these incompatible zonings as arbitrary and capricious. However, in the past few decades, the whole doctrine of spot zoning has been in decline in state courts because they said spot zoning is really just a label that gets put on it, and it might or might not be compatible or incompatible. And so instead, they're increasingly asked two questions. One is, is it fairly debatable that the zoning is rationally related to some legitimate government purpose? And secondly, is it consistent with the comprehensive plan? Okay, so that's where we've gone with spot zoning. But just, I don't want you, if somebody mentions spot zoning to you in the future, I do not want your eyes to glaze over like you've never had it. You probably say, yeah, I had Arnold for land use, and he never talked about spot zoning. Okay, so there's an interesting case in the reading. Hardin County, okay, so can local government zone an entire locality or a large area to allow only very few uses by right, say agricultural, single-family, residential, and then require everything else to get a conditional use permit? So make every use conditionally permitted except for one or two. And so in 1995, in the Hardin County case, the Kentucky Supreme Court says, no, you can't do this. This is the antithesis of comprehensive planning and zoning. In 2005, the Wyoming Supreme Court came to the opposite conclusion in the Laughter case because they say it allows for thoughtful growth management. You can make decisions on a case-by-case basis depending on what your growth patterns are, what the conditions are, and so forth. Now, having said that, the Kentucky Supreme Court does not get the last word on this. Turns out that the Kentucky state legislature then turned around and enacted section 100.202 of KRS, which says, subject to KRS 100.1373, nothing in this chapter shall preclude the legislative bodies and fiscal courts of cities and counties comprising a planning unit from enacting a land use regulation which places all property within their respective jurisdictions in a single zone and addressing all land use proposals therein as conditional use permits. Boom. So take that, Kentucky Supreme Court. Can the state legislature do that? Can the state legislature do that? Yes, the answer is yes. Okay, why? Because the Hardin County case was interpreting the authority to zone that had been granted by, if it is automatic turn off after a while. Had been granted by the state legislature. So, in essence, the Kentucky Supreme Court really was saying that the state legislature did not intend for cities and counties in Kentucky to be able to do this, and the state legislature stepped in and said, yeah, we actually do intend for them to be able to do this. Okay? So, that's something that is kind of interesting and useful to see. I'm going to keep talking, and I don't know what this is. It says the system is configuring, but I'm going to keep talking because I don't want us to get delayed. So I'm going to talk a little bit, but you'll get the PowerPoint on Blackboard, so you'll see the slides at some point. So one of the other things that has happened, and this these cases lead into it, is that we have now what's called post-Euclidean zoning. Okay, the modification of how we do zoning to allow more flexibility, more capacity for mixed uses, more negotiated outcomes. So now we have a lot more negotiated outcomes of land use regulations, where developers are sitting down with regulators, or with both regulators and community groups, and negotiating the outcomes. So we're going to spend some time later talking about things like planned unit developments and that sort of thing. And we're also seeing the government focus more on environmental and public benefits. A lot of use of conditional use permits, variances, development agreements, planned unit developments, and that kind of thing. I'm going to wait to another class to talk, probably next class to talk about some specific things like performance zoning and overlay zoning and that kind of thing. One of the issues, though, that comes up is that, there we go, governments, local governments tend to regularly amend zoning. Okay? So one of the questions is whether the action is a legislative action or an administrative action. Legislative actions are those actions that can be that are based on broad policy goals. They do not require evidence or findings. Okay? And it's entitled to a high amount of judicial deference. Okay, so if the Congress tomorrow enacts a statute that exempts, I don't know, law school textbooks from profits earned on law school textbooks from the federal income tax. Can they do it? Yes, right? I mean, what if the whole basis is that they're just like, we love law school textbooks for no reason whatsoever. I mean, it's totally nutty, crazy, irrational. Is the Supreme Court going to overturn it and say, no, you can't do it? No, of course not. Is there going to be any argument, well, they don't have any studies or evidence to support it? No, doesn't matter, right? A legislative decision can be based on policy goals, and as long as it doesn't infringe on somebody's constitutional rights, and as long as it is an exercise of the power that that legislative body has, they don't have to have studies, they don't have to have findings, they don't have to have evidence, they can just choose to do that for policy reasons. So that's a legislative act. Lots of judicial deference. Administrative actions, however, are where a particular project or a particular permit is being decided upon using existing legislative standards, existing standards adopted legislatively, and it has to be based on some kind of factual evidence. And usually, and in this class, always supported by findings of fact. There are some exceptions in certain areas of administrative law where there are not findings required, but in land use, findings are required and for administrative actions. Okay, so, and it doesn't matter which body is making the decision. It might be the Board of Zoning Adjustment, it might be the Planning Commission, but even if it's the elected city council, if it's an administrative action, they still need evidence and findings, and they have to follow the standards that have already been adopted. So what counts? Legislative acts are any adoption of the zoning code initially. Okay? So when a local government first adopts its zoning code or zoning ordinance, that's a legislative act. If it makes amendments to the text of the zoning code, That's a legislative act. Okay, it's broadly applicable standards. In a majority of jurisdictions, the rezoning, so a map amendment that rezones even single parcels of land or small areas, in a majority of jurisdictions, those map amendments, those rezonings, are legislative acts. However, in a minority of jurisdictions, the rezoning of single parcels of land count as administrative acts and therefore need evidence and findings to support them. All permit decisions are administrative actions, except we're going to get into some things that they're in a whole nother category called ministerial. And we'll talk about those next week. Okay? But permit decisions are administrative actions. But the point I want to make here is a minority of jurisdictions, the rezoning of single parcels of land are administrative actions. So, the classic case, this is a famous case, Fasano versus Board of Commissioners of Washington County. This case arose when the neighbors sued Washington County officials and the developer because the Board of Commissioners approved a zoning change for a 32-acre parcel of land from R7 to PR. So basically from single-family residential to a planned residential zoning designation that would allow a mobile home park. Okay? Now, pause for just a second and immediately see what this is about. This was zoned for single-family residence. It's now going to be a mobile home park. The neighbors are unhappy, right? And that's right. NIMBYism. They don't want the mobile home park, so they're suing the developer and the government, the local county officials. And that's very common kind of thing to happen. And eventually it makes its way to the Oregon Supreme Court. And the Oregon Supreme Court says that rezonings are administrative acts, or what they call quasi-judicial, which is another term that's used, but they are not legislative acts. Okay? And they say this is necessary in order to ensure compliance with the rezoning with a comprehensive plan, that the government must consider and find evidence that there is a public need for the zoning change, and the need will be best served by the new zoning designation. There must be a hearing with the opportunity for everyone to be heard, both the developer and the neighbors, an opportunity to present and rebut evidence, impartial decision maker, record of hearing and evidence, and adequate findings of fact to support the decision. Conclusory justifications or generalizations are inadequate. Okay, we're going to see this again. This is our standard, what's required. We're going to cover it again next week, so don't worry if we move past it fast. But this is actually a pretty substantial amount required for a rezoning. Okay, this is out there, right? This is a minority of jurisdictions, but the Oregon Supreme Court kind of caused a lot of uproar when it decided this, and so it was initially adopted by some states. It was rejected in some, and some states that initially adopted it ended up regretting it and reversing their decisions. However, even though it's pretty extreme, there are a couple of exceptions, a couple of states that have even tougher standards for rezonings, and that is the change or mistake rule. Maryland has this rule. Supposedly New Mexico has it, but it doesn't seem like they ever follow it anymore. So I don't know if it's been overruled or what the deal is, but at one time New Mexico followed it, which was no rezoning allowed without proof of change in neighborhood conditions or some sort of mistake in the initial zoning. So that's very limited. But here's yet another example. So okay, we're all still talking about the minority of states. But 1993, okay, the Board of County Commissioners versus Snyder. Okay, so this is not a situation where the rezoning was approved and the neighbors were unhappy, but it's the opposite. Okay, so this is where the developer is unhappy. So landowners sued the local officials who denied rezoning of land from low density residential to higher density residential. Okay, so it started out, the planning staff objected to the proposed development because the property was in the floodplain. This is a very common pattern. The developer says, well, I'll just add some dirt and raise the property above the floodplain level, okay? Right? Anybody familiar? This is a very common pattern. Of course, eventually, what's going to happen is the property will flood, okay? So, but they try to get around the technical prohibitions on developing the floodplain by just plopping some dirt down and building on top of it, okay? But the neighbors objected to the increased traffic for the development, so the Board of County Commissioners then denied the rezoning but didn't say why. Okay? So the Florida Supreme Court, Florida Supreme Court says small parcels rezonings are administrative, large area rezonings are legislative. They say this is necessary to ensure consistency with comprehensive plan and with state statutes. So one of the things that is different about Florida is it is like a handful of states. There's Oregon and Washington are like this, Vermont's like this, Hawaii's like this, but it is a state where there are a fair amount of state statutes establishing very detailed standards for growth management and land use regulations. So more state involvement. They say that decisions involving small areas of land are by their nature an application of policy, whereas decisions of large areas of land can be about making policy. The landowner, it starts out where the landowner has the burden to show that the requested zoning is consistent with the comprehensive plan and that the landowner has complied with all zoning ordinances. But then, at that point, the burden of proof shifts to the local government to show that not changing the zoning accomplishes a legitimate government purpose. So what does that say? There's a presumption in favor of rezoning when the landowner requested, right? Does everybody see that? Wow. The court interestingly says, okay, even though this is an administrative action, no findings of fact are required, but they will review the record, the courts will review the record to make sure the decision is supported by substantial evidence, but also that it's always better to make findings of fact. And once again, you will hear this many, many times, but in this course, we make findings of fact, okay? That is required, actually, in many states, and so this is a weird case, and so forth, okay? Let me just say, though, that, again, in the majority of jurisdictions, any rezoning is a legislative act and gets great deference from the courts. No findings are required, no evidence is required, okay? And that includes Kentucky, by the way, legislative act. Last case to touch on is the Mendota Golf case. So this is one where the city council denied the landowner's application to change the property's comprehensive plan designation from golf course use to residential use. The zoning designated the property for residential, the plan designated it for golf course, and there's a state statute in Minnesota that requires cities to resolve conflicts between plan designations and zoning designations. Now what happens here is, of course, the city officials want this to continue to operate as a golf course. Okay? Right? They do not want this landowner to change the land use. They like this golf course. They want it to continue to exist. Okay, that's private, but they want to make sure that this golf course amenity stays, and so they refuse to change the plan designation from golf course use to residential. And so a lower court issues a mandamus, which is a writ that basically orders the court, orders the local government to change its plan. And they say, hey, the lower court says, hey, it's residential, and the city cannot force the landowner to continue to use it as a golf course, so the city must change the plan. And then it gets to the Minnesota Supreme Court, and the Minnesota Supreme Court overturns that mandamus. And they say, actually, we're not really opining on whether it must be a golf course or a residential. Okay, they said, it's, so among other things, if the golf course is unprofitable and the landowner cannot convert the land to residential because the plan won't allow it, they can bring a takings claim against the city and get compensation. But what they say is the lower court does not have the power to force the city to resolve this conflict between the plan and the zoning code by picking one method over another. What they're saying is the lower court decided for the city whether the plan should prevail versus the zoning, and of course they picked the zoning, so it had to be changed to residential, and that is not, that's beyond the judicial authority. That basically involves the court making a legislative decision. So for example, it might be permissible for the court to issue a mandamus requiring the city to make a choice. Okay, that would be a legitimate exercise of the judicial power to say that, okay, there's a conflict between the plan and the zoning, and the city has to make a choice. But for the court to make that choice involves the judiciary making the legislative decision, and that was what was impermissible in the Mendota golf course, that golf case. Okay, so we're done. The lecture. Questions? Next week, we're going to look at permits and the standards for permits. I want you to look at the Anaheim case study and come prepared to discuss it. So we'll spend some time talking about that. We will also talk further about some of these various flexible zoning methods because that will make more sense when we talk about the permits. What we're going to do now is go to the Allen courtroom. Team 1, go ahead up to the bench, to the decision-making role, and sit in those chairs, as many of you as fit, and others can sit on the side. And Team 2, whoever your representative or representatives are, go ahead to the podium and be prepared to present.
We have it. Designated someone about it.
You guys have it?
I don't think anybody.
Just draw straws.
Be an attendance roster.
Too much of a risk.